This is the keynote lecture to the Conference on Constitutionalism and the Free Society. It is also a contribution to the ongoing Research Group on Constitutional Studies lecture series. And while the Constitutionalism Conference has a rule against substantial introductions, the Rgcs lecture series very much does not, and so the conference rule is waived for current purposes. I'm Jacob Levy. I'm the coordinator of the Research Group on Constitutional Studies and the director of the Jan P. Lind Center for the Study of Freedom and Global Orders in the Ancient and Modern Worlds, of which Rgcs is a part. The Research Group on Constitutional Studies brings together scholars at all levels from across McGill who work on political theory, political philosophy, legal theory and philosophy, public law, constitutional law, and constitutional level empirical political science. And the conference of which this lecture is a part is an attempt to bring those themes together along with colleagues from outside McGill and from around the world looking at those same themes. The Rgcs lecture series, which has existed for nearly as long as Rgcs has, aims to bring leading scholars from around the world working in the social sciences, law, history, and philosophy to come speak about their research in ways that are accessible to an educated student audience about the values, institutions, and principles of a free society, aiming to overcome the traditional barrier that separates researchers who travel around the world to talk with other researchers about their research and intellectual entertainers who travel around the world to talk to undergraduates. We have found very consistently that great scholars are often also great teachers, and great teachers know how to talk to great students. And we aim to bring those communities together in this series to, I think, considerable success over the years. And so the Rgcs lecture series is directly connected with the Research Group on Constitutional Studies Student Fellowship, which is the program by which undergraduates, master's students, and law students are brought within the umbrella of Rgcs. Today, it is my delight and honor to welcome to the Rgcs lecture series, Professor Melissa Schwartzberg. Melissa Schwartzberg is Silver Professor of Politics at New York University. She is also an affiliated faculty member in the Department of Classics and in the New York. She is, very simply, one of the most creative, capable, and knowledgeable political theorists of our generation. We aim as political theorists to be able to do more than one thing at a time. We aim to be able to say something about normative questions about how politics ought to be governed, and something about the history of political thought and the ideas that have gone into informing those conclusions about how politics ought to be governed. Some of us aim to have something to say about law and jurisprudence. Some aim to have something to say about institutions and politics in a way that can move into conversation with our colleagues in empirical political science. Melissa Schwartzberg does all of those things and does them all at an extraordinary level of quality. She's the author of 2 books, Democracy and Legal Change from Cambridge University Press in 2007, and Counting the Many, The Origins and Limits of Supermajority Rule, published by Cambridge University Press in 2014, which was awarded arguably the most prestigious prize that our subfield has to offer, the Spitz Prize from the International Conference for the Study of Political Thought. She has been a Mellon Foundation New Directions Fellow and is this academic year both a Guggenheim Fellow and an American Council of Learned Societies Fellow. Of majoritarian, democratic, legal, and constitutional change, drawing on tools from the institutional analysis of the democratic procedures in ancient Greece through engagement with formal choice and social choice analysis today. She is the general editor of the Nomos series published by the American Society for Political and Legal Philosophy, in which capacity she has managed the astonishing feat of getting 5 volumes from that series published in the space of 3 years. She has served the profession in an extraordinary number of capacities, up to including serving on the editorial board of the American Journal of Political Science. She is also a longtime friend of RGCS. She was the co-organizer, along with myself and Josh Ober, of the conference on political theory in and as political science, which was, up until this event in its virtual way, the largest event that RGCS has ever sponsored. And here she is in her last visit to RGCS at McGill at that conference 3 years ago. Her scholarship is fully in engagement with not only the themes of the political theory in and as political science series, of which she is an ongoing co-convener, but also with the themes of this conference on constitutionalism and the free society. And we are honored to have her with us, speaking to both the conference and the RGCS lecture series today. Melissa.
Thank you so much for that really lovely introduction. This is such a remarkable group of scholars, and sad as I am not to be at McGill for its bicentennial, the Zoom world does allow so many more people from all over the world to join this excellent conference who otherwise might not be able to attend. And it's wonderful to know that all of you are here. Okay, I'm going to share my screen now. The collection of intimate personal data by the state has never been as comprehensive or as efficient as it is at the moment. Those of us lucky enough to have access to our offices or to our children's schools have become habituated to institutions testing us for COVID, to ubiquitous temperature checks, and to filling out online screeners. We may have downloaded apps that alert us if we have been in close contact with someone who tested positive for COVID. And some of us may be on the cusp of using apps to reveal to restaurants, cultural venues, airlines, or foreign states that we have the fortunate status of having been vaccinated. Contact tracing has been a powerful tool in the world's fight against COVID, but it does raise obvious worries about the use of tracking data on the part of the state, not for the first time in recent memory. Many Americans had their eyes open to the collection of data by the National Security Administration, by Edward Snowden's leaks. And of course, the American government is far from alone in its extensive use, justified by the aim of public health. New tools for contact tracing have enabled states around the globe to track the movements of its residents, and predictably, states have also frequently declined to reveal the other purposes to which they intend to put this data. This afternoon, my aim is not to preach the gospel of privacy rights against the state. Well, not entirely. Instead, I will suggest that the state has always sought to collect information about its inhabitants. The technologies by which the state has done so have changed dramatically, but the incentives in many ways have not. To use Jim Scott's language, the state needs to make its domain legible to perform its basic capacities. And I will argue that the assignment of political rights constitutes a step in that process. And this raises several important questions for political theorists and political scientists interested in constitutionalism, understood for now broadly as the possibility of enforceable limits on the state. These questions include the scope and nature of the information the state may permissibly seek to collect, whether we should understand it as bounded, and whether in cases of emergencies, such as pandemics, these limits may be breached. And they include whether the inhabitants of states, citizens, permanent residents, and undocumented persons alike, can or should seek to render the state accountable for its use of this information and how. And there's a tightly related question to the first and second, which is the following. Will increases in accountability, in fact, disincentivize the collection of information that may reflect poorly on those in power to the harm of the polity? But the circumstances I am most interested in exploring this afternoon are cases in which the state requires information that is possessed at the local level by ordinary community members, particularly relatively vulnerable community members, and how the dependence of the state on this knowledge may create opportunities for these members to bargain over their status. My argument generally is as follows. At moments at which the state's need for tacit knowledge held at the local level increases, ordinary people find themselves valuable to the state in a distinctive way, specifically in their capacity as knowers. Under certain circumstances, their local knowledge can serve as a basis for wider gains in terms of their political standing. The state's recognition of their status as epistemic agents enables them to become fuller political agents. They may be able to secure access to institutions from which they were previously excluded, and they may be able to secure certain protections from domination by others. At least so I will claim. And to do so, I will spend much of our time today teasing out a historical parallel. That is 14th and 15th century England in the wake of the Black Death, which killed perhaps half the population beginning with its first wave in 1348. Here, as I will discuss in a moment, so England experiences this enormous shock to its population, but it also reduces the number of high status individuals and the incentive of high status individuals to serve in institutions that convey information to the crown. And so this presented an opportunity for peasants, particularly unfree peasants, one that yielded important gains in terms of their political standing in the 15th century that were of epochal significance for the history of representative government, the 40 shilling freeholder statutes. Before I begin my historical inquiry, I want to address a few thoughts that may have already occurred to the political theorists. First, in recent years, there has been sustained interest in so-called epistemic democracy, the circumstances under which democratic decision-making can yield right answers to difficult questions. Toward that end, many scholars have advocated a set of mechanisms by which lay citizens' knowledge can be aggregated, often, but not necessarily following deliberation, to produce wise results. My argument today departs from the ambition of the epistemic democrats in many respects. I share with them the fundamental belief that local knowledge possessed by ordinary citizens is a necessary component of competent and just state action. A necessary component, but it is very far from a sufficient one. That is because, as I've already said in the few minutes we've been together, and will reiterate throughout this talk, all states, whether democratic, authoritarian, or some form of hybrid regime, have an incentive to collect local information. The question is when they can be properly motivated to use this information for the public benefit rather than the interests of rulers. That is, unless we are Platonists, we need to remember that knowledge itself is motivationally inert. We require accountability mechanisms to induce state actors to use it well. And so part of my secondary aim in today's remarks is to encourage political theorists to think critically about the circumstances under which the institutions that encourage knowledge revelation on the part of ordinary citizens, such as the deliberative bodies termed citizens' juries, when those institutions will improve responsiveness to citizens' needs, and when they might merely enable more efficient and effective coercion on the part of the state. My main focus today is a watershed period in the collection of local knowledge, medieval England. The Crown's need to raise revenue has long served as an explanation for the emergence of representative institutions. The Crown, as is well known, was habitually short of funds. From Magna Carta forward, these fiscal needs produced political concessions on the part of the Crown, and this is considered to be a turning point in the history of constitutionalism. Indeed, this is very nearly a platitude among economic historians. The Crown's ability to extract tax revenues was enhanced by institutions that enabled its subjects to consent or to exercise some limited control. But in fact, the Crown often lacked fine-grained knowledge as to its property holdings and other sources of revenue, and so it needed to solve the informational problem before it could solve the extractive one. Juries constituted the solution to the informational problem, beginning at least with the Domesday Book of 1086. King William I lacked the administrative resources to conduct this survey by royal officials and relied instead on small groups of local people sworn by oath to provide the information for the survey of local assets and conditions. Henry II in 1170 commissioned an inquest of sheriffs by jury, designed to solicit information about corruption on the part of sheriffs, the collection of taxes, and the income of all lords in the kingdom. Edward I's Quo Warranto inquest in the 1270s addressed a variety of misdeeds pertaining to exports of wool and toll collection, particularly on perprestures, which constituted enclosures on the king's highway or property. The aim of the inquest, again conducted by jurors, was to account for those perprestures for which the king could receive a fine or rents for licenses. But these jurors did not simply seek to promote the king's interests. Rather, they saw these enclosures as in violation of the common welfare of the community. They complained that they were nuisances that affected the whole city as well as the king. And so even from these early periods, the interests of jurors could sometimes align with the interests of kings against other community members, especially including elite members. This will be important, as we'll see in a moment. Let me also note for political scientists that geography played a major role in explaining the emphasis on juries as a source of local knowledge. The smaller size of England, relative to France, for instance, reduced transaction costs, as Margaret Levy has argued. My colleague, David Stasavage, has similarly argued that size affected the ability of members to attend representative assemblies, and thus the growth of such institutions. No less than Sir John Fortescue, writing in the late 15th century, pointed out the informational value of a smaller and more densely populated territory in explaining why England relies on 12 sworn men and other kingdoms do not, observing, how then can a jury be made up in such regions from among 12 honest men of the neighborhood, where the fact is brought into trial, when those who are divided by such great distance cannot be deemed neighbors? Let me immediately confess that one difficulty in conducting research in this period is the frankly bewildering number of legal institutions. In late medieval England, which is my focus today, most importantly, there were manorial courts, the key institution for medieval English villagers, but there were also leet courts, which exercised jurisdiction from the king. There were also ecclesiastical courts, which had jurisdiction not merely over spiritual conduct, but defamation, agreements to marry, and in general interpersonal relationships. But there were also very many other courts, borough and mayoral courts, market courts, admiralty courts, port courts, and forest courts among them. And all these courts had to be staffed by jurors. My focus today are going to be primarily on courts with royal jurisdictions rather than local juries. As historians have argued, from the inquest grew presentment juries, which presented information to officials. The first clause of the Assize of Clarendon in 1166 stipulates that juries should be constituted in every 100, which is a region, to furnish information on oath to sheriffs and royal justices about robbers, murderers, thieves, and anyone who had aided and abetted them, and that another jury drawn from the villages should present those who were publicly suspected of committing a felony. There were also possessory assize juries, which resolve property disputes, largely between lords and tenants about encroachments on the claims of the latter by the former. Royal justices presided in these cases, bolstering the crown's authority in resolving these disputes. Here too, there is a way in which the interests of the juries in settling these pervasive and disruptive conflicts could at least sometimes be aligned with the king. The assize was a royal procedure, so fees and fines associated with it went to the royal treasury. And then there were the trial juries, which over time rendered verdicts, spoke the truth, on a range of issues, not merely criminal wrongdoing with capital punishment, but the status of a person as free or unfree, disputes about burdens that lords placed on peasants, forms of trespass, interference with lands, goods, or persons. In general, I'm going to emphasize three forms of information that the Crown sought. Information about revenues that the king could collect from inquests after the death of tenants-in-chief who held land directly from the king. Information about the performance of local officials, which they would have received largely through presentments, and a variety of threats to law and order and local stability, which trial juries as well as presentment and assize juries were able to convey. I can only discuss these very briefly here today, and it's part of my ongoing research at the moment to investigate the various forms of knowledge that these juries were designed to convey. I should also say that the work of medieval historians is ongoing in what is termed prosopographical work. It's mapping the families and relations among families who served. What I'm about to discuss is in certain respects preliminary and conjectural, but I hope to give you some suggestive evidence, drawing largely on the work of medieval historians in support of my claims. There were different statutory requirements for jury eligibility. Jurors in the royal courts in the 13th century were expected to be knights or quite substantial property owners. Even then, though, there was difficulty in securing the wealthy, and sheriffs and bailiffs who were organizing these jurors were liable to include poorer people. The introduction of formal qualifications, beginning with the Statute of Westminster in the late 13th century, was in part due to this. This itself was the first use of the 40 shilling rule, which we're going to discuss much more in a moment. It specified that if a jury on which an individual was chosen to serve delivered its verdict within its home county, the juror needed to have lands capable of producing an annual income of 20 shillings. If the jury delivered its verdict elsewhere, as in Westminster, then the property qualification was 40 shillings. More on this in a moment. In general, though, the standard description of those eligible to serve as jurors were free and lawful men. But the extraordinary demands for service meant that the terms free, lawful, and men were all elastic, even in the centuries prior to the Black Death. Women were excluded, except when they were not. Cases in which a plaintiff in a case of sexual assault sought to defend himself by insisting the woman was still a virgin, and cases in which a female defendant pled the belly, claimed that she was pregnant to try to ward off execution, were cases in which women would be impaneled. What lawful meant could vary. It generally meant independence of judgment, someone who was not beholden to another, like a servant, a child, or even a monk. But one's identity as a lawful person could be affected by ill repute or the allegation that one had broken an oath. And free typically meant not a serf, or what, as they're usually termed, villains. But ascertaining whether one was free or unfree was not always straightforward. And royal administrators did tacitly allow villains to serve, even though there were consequences for officials were this fact discovered. So, although these exclusions were imperfectly enforced, they also did not generate a systematic improvement in the standing of unfree peasants in particular. That required the transformations and the changes in bargaining power generated by the Black Death. Now, as today, it would seem that jury service was an unwelcome duty to be evaded. And no doubt it sometimes was. People paid to be exempted from service. But at the same time, eligibility to serve was one of the most crucial markers of standing in the period. It was a key means by which peasants in particular were able to mark and enhance the status of their families. And in part, this is likely due to the earlier history of the jury and the high standing of those eligible to serve. In analyzing court rules, medieval historians have also shown that jury service was hereditary in the sense that certain families were associated with the distinction of serving. Historically, the longevity of the family in an area was a key criterion in jury selection. Ideal jurors were men of long-time residence and known familial and social backgrounds with excellent local reputations. They possessed the requisite knowledge to render judgments valuable to the crown, and sufficient local authority to have their verdicts respected. One such historian, Robert Goheen of Carleton University, first argued 30 years ago that such service was a strategy of the upwardly mobile, relatively wealthy peasant family in its quest for status and authority. But the population shock and the deterioration of socioeconomic conditions more generally after the Black Death provided an opportunity for peasant families who had been well below the formal qualifying criteria to stake their claim. Political scientists and economic historians have long examined the effects of the Black Death on other elements of peasant life, notably its effect on peasant incomes and the general decline of serfdom. Most recently, Acemoglu and Robinson have traced the effects that the massive scarcity of labor had on the feudal order more generally, in part through changing the bargaining power of peasants. There are many examples of peasants demanding new terms or rejecting the terms on offer. Acemoglu and Robinson cite an example at Ainschen Abbey at the time of the mortality and pestilence, in which two tenants of the manor expressed their intention to leave, unless Brother Nicholas of Upton, the abbot and lord of the manor, made a new agreement with them, which he did. In response to the dramatic rise in wages and the efforts of peasants to renegotiate, Parliament under King Edward III in 1351 passed a statute of laborers, seeking to fix wages at the levels below the Black Death and to prosecute those who fled from their masters. But lords sought to evade the statute through giving extras like grain allowances to secure sufficient workers. Moreover, jurors were required to give these statutes teeth, and they were not consistently willing to enforce them. In 1373, the vills of Gramsby, Swinhope, and North Thoresby were described as rebellious and would not come to present in front of the justices, the Lord King. Failures of individual jurors to appear in this period are regularly reported in the rolls, and in some instances, presentment juries may have declined to provide complete information. A suggestive example from the period. The jury present that Agnes Dow, the Lord's serf, has abandoned the land of the Lord and fled to Newcastle, where she has married a cobbler without the Lord's license, but they do not know his name. In addition to resistors, the population reduction in the years following the Black Death led to a substantial decrease in the pool of those previously eligible to serve as jurors. To compensate, new men whose families had rarely served in the years prior to the plague came to serve as jurors and other officials. As the great medieval historian Christine Carpenter has observed, this was a moment at which prosperous peasants, grown rich on the misfortunes of their social superiors, as well as merchants and lawyers, were able to aspire to gentility and acquire estates. But the poorer freeholders who had entered the landmark in that period after the plague were excluded from vindicating their claims to title in the royal courts, and wealthier serfs were not only frustrated by their formal exclusion from litigating in these courts, but from serving on juries there, and they took these exclusions to constitute a form of dishonor and stigma. At the same time, the need for the information provided by juries, particularly about revenue sources for the crown, had sharply increased. Taxation was intended for the common defense, and the imposition of poll taxes had in fact been one of the causes of the Peasants' Revolt in 1381. By the late 14th century, the view was that the king should live on its own resources. And it had very high expenses, including household expenses. Richard II's archers alone cost £5,000 a year. So one solution was to try to collect all of the revenues to which the crown could possibly lay claim without taxation. And so there were a variety of sworn inquiries by which the crown could collect information pertaining to their feudal rights and derive revenues from their lands. One important mechanism was the Inquisition's postmortem. Initiated by the crown, these IPMs were produced by sworn inquiries by local juries into the land holdings after the death of feudal tenants. A writ of Deum Clausit Extremum, he has closed his last day, initiated it, ordering the escheator in a particular county to take his lands into royal custody and hold an inquisition. Jurors were asked questions such as the date when the tenant died, the nature of the tenant's holdings, its value, the heirs of the deceased, and the age of the heir, so as to determine whether the heir could be taken into royal custody and the gains from the property passed to the crown while the person was still in the minority. When the question was the child's age, the stories provided by jurors to establish the date of their birth or baptism were especially rich. 4 men who were present at the baptism of John, son and heir of Roger Mortimer in 1392, drank wine which was brought to the church, and such was the effect that they could hardly walk out of the church. But in general, the main goal was to identify property held directly by tenants, or what could accrue to the king by default, and to extract any value. From a historical vantage point, the IPMs are especially important as the first official publications of royal inquisitions to include all the names of jurors. There are volumes from 1236 to 1509, which have been digitized from 1399 to 1477, and they include 48,000 names of jurors. Medieval historians have preliminary findings already, suggesting that, in fact, after the Black Death, the jurors were at best the middling sort. Gentry basically did not serve in the IPMs at this point, and the lists offer barbers, butchers, skinners, and drapers. A list from Wallingford from 1438 identifies 6 laborers, potentially servants. An attraction of IPM service in particular, Matthew Holford has written, is as a badge of respectability and authority that would enable a person to distinguish himself from social inferiors. But the escheator, who convened the jurors, was perfectly clear on the social distinctions, as Christine Carpenter has suggested. Near identical lists of jurors are not identically ordered because, in her words, the escheator felt that the jurors were all so plebeian as to make distinguishing between them odious. But from Carpenter's intensive study of the Warwickshire jury lists, wherever there's a juror of even marginally elevated social standing, he's at the top of the list. The Crown, of course, had concerns beyond the financial. As I mentioned, they also sought information about authority and order in local communities that might impede their ability to keep the peace. Medieval criminal law reflected the view that a person who committed a felony had not only wronged the victim, but the king. Jail delivery circuits, which emerged in the early 14th century, so prior to the Black Death, technically included a precept for the sheriff to summon panels of 24 knights and other free and lawful men, each of whom had 100 shillings of land or rents per annum from the township where an offense had been committed. This, as historian Edward Powell has noted, was completely impracticable. There were 91 prisoners from Nottinghamshire and Derbyshire to be delivered at Nottingham in July 1412. A panel for each, he has calculated, would have required over 2,000 men from the 2 counties, each with a landed income of £5 per year. And so Powell has argued that, more realistically, a statute of 1414 stipulated an income of jurors specifically in cases of homicide, implying that a smaller income was acceptable for juries trying lesser felonies. And so here's where we come to the crux of this historical inquiry. We've now seen that after the destruction of the Black Death, the king's informational needs were at least as sharp as they'd ever been, and perhaps even more significant in the wake of the Peasants' Revolt. For centuries at this point, the key provider of information had been juries, but at least for royal courts, if not the main manorial courts, there had been some effort to keep the status of those impaneled relatively high, knights or gentry, or at least the wealthiest yeomen. After the Black Death, this was not sustainable. The needs of the crown were too significant and the personnel too diminished. And so the sheriffs and escheators and other conveners of juries found themselves increasingly drawing from the lower ranks of the peasantry, people with something to gain for their service. Now, what they sought from jury service surely varied. I have already suggested that for many ambitious peasants, the main aim was relative standing in their community, and for villains, an institutional means of obscuring their unfree status. Others, and this will be important in a moment, sought the opportunity to hold local officials accountable via the crown. And given the demands of royal justice, sheriffs were increasingly willing to fill the jury with anyone whose personal reputation had not made them obviously unlawful, but not without resistance or increasing concern. So in 1413, there was a fruitless petition to the crown against corrupt jurors, who received from one party or another various sums of gold and silver and other goods. Although the response to that one was merely, the king will consider this further, indicating perhaps some skepticism about the plausibility of the claim, the next year featured another more successful petition. This petition was against embracery, influencing jurors, and champerty, bringing suits for gain. The Commons pray that it may please our Lord the King to consider the great oppressions, disinheritances, and injuries which are suffered daily by many lieges of our Lord the King from many parts of England, at Westminster, in the courts of our said Lord the King, through the notorious behavior of embracers, champerters, and maintainers of quarrels of and in the county of Middlesex, and also through the behaviors of the jurors in the same county, in numerous false and feigned suits held in the same county, because the jurors have only a little to live on from lands or rents, and nothing to lose by false oaths, and to ordain and establish that no juror of the said county should be returned or allowed to on any inquest between party and party in the same county in any real plea or in any personal plea in which the death of the declared damages amount to 40 marks, if he does not have lands or tenements to the annual value of 40 shillings net. As mentioned, there had been previous statutes defining eligibility for jury service. Notably, in 1293, a statute implemented a 100 shilling threshold for service outside the county, 40 shilling within the county. That latter threshold doubled the prior rule from 1285 of 20 shillings. But the statute that immediately followed, the statute from 1414 that followed the petition, does not specify any geographical bounds, and it reads as follows. The king, considering the great mischiefs which daily happen through all the realm of England, by them which pass in inquests in the said cases, which be common jurors, and others that have little to live upon but by such inquest, and have nothing to lose by the cause of their false notes, that no person shall be admitted to pass in any inquest, if the same person have not land or tenements of the yearly value of 40 shillings above all charges of the same. This statute, I believe, attempted to reestablish a threshold that had been widely breached on the ground, while effectively nullifying the 100 shilling threshold for service outside the county. It responded, as the petition and the bulk of the statute acknowledges, to the supposed worry that impoverished jurors were flooding the courts and were susceptible to bribery because they had nothing to lose. Now, I suspect, given this audience, that the invocation of the 40 shilling rule may have immediately rung bells in your head. This is because of the famous 1429 to 1430 statute, conferring the franchise on all those with 40 shillings of income from freehold land, and matching the qualification for jurors. And indeed, it seems that the dynamics and justifications for this statute match those of this earlier one for jurors. The worry that poor peasants had flooded the institution. Whereas the election of knights of shires to come to the parliaments of the king in many counties of England have now of late by many great, outrageous, and excessive numbers of people dwelling within the same counties, of which the most part were people of small substance or no value, whereof every of them pretended a voice equivalent as to such elections to be made, with the more worthy knights and esquires dwelling within the same counties, whereby manslaughters, riots, batteries, and divisions among the gentlemen and other people of the counties shall very likely rise and be, unless convenient remedy be provided in this behalf, the knights to come to the parliament shall be chosen in every county by people dwelling and resident who have free land or tenement to the value of 40 shillings by the year, at least above all charges. And that they which shall be chosen shall be dwelling and resident within the same counties and have the greatest number of them that may expend 40 shillings by year and above, as afore is said, shall be returned by the sheriffs of every county, knights of the parliament, by indenture sealed betwixt the said sheriffs and the said choosers so to be made. So here we have a crucial moment. We have the beginning of parliamentary election according to majority rule in response to poor peasants crowding their way in. Note that the first provision aims to eliminate men of small property or no worth, who allegedly are creating these terrible disturbances, and there are going to be manslaughters and riots and batteries and divisions. A 40 shilling qualification would have enfranchised at least the middling among the peasants, yeomen and husbandmen, farmers. The wealthiest counties had electorates of over 1,000. By mid-15th century Nottinghamshire, only a fifth of the enfranchised population were gentlemen or above. And the second part of the statute is the introduction of majority rule, the greatest number, into parliamentary elections, by which the gentry there were to be counted on equal terms with their social inferiors, albeit with this lower bound of 40 shillings enforced. This is among the most significant developments in the history of what still remains an ongoing struggle for political equality, free elections, and constitutional protections. I believe it clearly emerged in the wake of the changes in bargaining power after the Black Death, and I believe the bargain was in no small part about the Crown's access to local knowledge. Again, what was at stake for these jurors and voters? What, apart from the standing that service afforded, why would they have wanted to participate? Well, part of the reason was the opportunity to hold lords to account. As I've said, the Crown was interested in the performance of royal officials, whose misbehavior was a common source of petitioning and whose malfeasance impeded the credibility and power of the Crown. As the medieval historian Michael Bailey has argued, to improve accountability, individuals were encouraged to observe royal officials and bring forth allegations concerning misdeeds. To be sure, this might be related to some of the financial concerns. The Crown was especially interested in officials who might skim off some of the fees owed to the Crown, those who shipped wool without customs licenses. But from the jurors' perspective, service in the Crown's tribunals offered a distinctive opportunity to hold local leaders to account. The medieval historian Tom Johnson, in a remarkable new book, Law and Common, which I really recommend to all of you, discusses the jurors in Buckinghamshire in 1440 in the Court of the Verge. This was an itinerant tribunal under the jurisdiction of the Royal Marshal. Given the opportunity to report to the king treasons, felonies, trespasses, nuisances, the jurors chose to complain that the highway between Ivor and Drayton often flooded because the dean of St. Paul's Cathedral had neglected for 12 years to repair a wharf. And as we have seen, since one of the main obligations of the knights serving in Parliament was to present the grievances of their communities through the common petition, serving as an elector enabled one to have a claim to share in these petitions and to hold officials accountable. Among the themes that recur in the petitions from the period are the abuses of the royal officials in the localities and unchecked crime and disorder. So both the Crown and the local classes of the middling peasants gained from exclusion at the expense of the upper classes. Just briefly, here's one example of a customary tenant, likely unfree, a husbandman or farmer who availed himself of all of these new opportunities. He and his wife and daughter held this life tenancy of a messuage, of a cottage, and half a verget, which is approximately 15 acres, which seems to have been probably sufficient to basically just meet the 40 shilling level. But he served in many roles. He delivered the personal possessions of a hanged Bisley felon to the receiver of Bisley. He was the jury on an assize. He was the juror on an IPM. He was absent from another summoned jury. And he served as the juror before justices of the peace. This was exactly the type of the peasant who would likely have been excluded from service in royal courts before the Black Death, but who was made newly eligible afterwards. So let me recapitulate the basic argument and some of the implications. We have long known that the population shock after the Black Death provided peasants an opportunity for bargaining over land tenure and wages. But what historians have not usually addressed is the opportunity to bargain over information pertaining to local knowledge. Even though it is very nearly a commonplace among late medieval historians that juries constituted the eyes and the ears of the countryside, and that by the mid-15th century, the jury system ran on peasant participation. My argument here has been that at a moment at which the Crown's need for information about non-tax sources of revenue, the performance of local officials, and sources of disruption to the king's peace was especially sharp, even relatively poor and unfree peasants were able to access these institutions as a means of securing their own standing and holding oppressive officials to account. Via the jury, they rendered not merely judgments, although they did that as well, but conveyed or declined to convey information about their local communities. They recognized well the strategic value of information to the Crown, and so they were sometimes willing to withhold it, to refuse to render verdicts, or to report omnia bene, all is well, to officials probing into their communities as a mode of resistance well into the 15th century. Through the electoral process, peasants were at least formally eligible to play an equal role with the gentry in selecting representatives, who would then play a main role in the Commons petitioning process, conveying their local concerns. And by the 1450s, it was these freeholders who were the primary actors in rebellions against the abuses of corrupt officials of the Crown. I have argued that following the Black Death, centuries before the Glorious Revolution and the institutional developments so well analyzed by economic historians, bargains between peasants and the Crown over access to local knowledge constituted a watershed for constitutionalism. But now I want to return us to our plague times and to the need for information on the part of our states. If there were any question about the extent to which the effective functioning of the state has become dependent on digital technology, the response to COVID-19 must have resolved it. To be sure, in many developing countries, the constraints of limited internet availability and cell phone ownership have hampered efforts to map the spread of the virus. But in developed states, democracies and non-democracies alike, effectively tracking and limiting the spread of COVID-19 has depended on such data. The more comprehensive the data collection, it would seem, the better the outcomes with respect to COVID. Singapore and South Korea were at the forefront of tracing and testing, and both are success stories, particularly relative to the rest of the world. But exceptional performance in aggregating information has come at a cost to individual privacy, both within and outside democracies. And it is far from obvious what the long-run implications will be for citizens. In Singapore, the Trace Together app and token are used by 78% of the population. And in certain respects, the Singaporean app does aim to protect privacy. It relies on Bluetooth on users' phones to monitor other phones in proximity rather than on GPS data. And the Bluetooth data is anonymized and deleted from users' phones after 25 days. But although Singaporean authorities had originally said the data was encrypted, stored locally, and only used for COVID tracing, it came out that it had been used in a criminal investigation. A law then was quickly passed restricting the types of offenses for which the data might be used, and specifying that personal information must be deleted at the end of the pandemic, whenever that is. But this too has been met by skepticism and concern that absent explicit limits on state powers, the state could decide to expand the conditions of its use. South Korea also performed well in controlling the spread of the virus, but there the government used phone location data to alert anyone who had been in proximity of a person who tested positive, sharing information about the attributes of that person. Notably, authority distributed such information about those who had visited nightclubs popular with the LGBTQ community after a cluster of cases there, leading to fears of outing and discrimination. We might well believe that during a pandemic, such intrusions into privacy are warranted to secure the public welfare. But it is also worth noting that those who most fear these intrusions tend to be the most vulnerable in our community, including undocumented persons, may seek to evade tracing. And insofar as states require the transmission of sensitive personal and private information to access vaccines, data collection may constitute a barrier to the achievement of herd immunity. For those who have been lucky enough to be vaccinated, The use of health passports may pose other challenges. My home state of New York is developing a health passport known as the Excelsior Pass, which will display a QR code on a smartphone to be scanned before entering an indoor business or public gathering, which allows the bearer to be verified as vaccinated against COVID or having received a recent negative test. Apart from the invocation of blockchain, though, there's little information about the extent to which the privacy of the data will be secured and whether it will be made accessible by the police or other state and non-state actors. So more generally, the state of privacy law in most of the common law world is insufficient to meet current challenges. In the United States, federal privacy legislation is urgently needed, potentially akin to the Consumer Privacy Protection Act currently under consideration in Canada. And we need legislation to address not merely the state use of such fine-grained local information. Companies that aggregate, share, and use such data must also be subject to greater control. This is not merely a problem of state domination. As in the post-plague world, the post-COVID world may then present a distinct opportunity for bargaining over this type of legislation. We know that states will seek to use this data for all sorts of purposes, and so it is time for us to think carefully about the conditions under which we should allow them to do so, particularly for those who lack full political rights. We have already seen intimations of such in the United States in the response on the part of some states to the Trump administration's requirement that states sign data use agreements that commit them to sharing personal information for a national registry before receiving doses of vaccines. States such as Minnesota and New York pushed back, refusing to report identifying details to the CDC. Although there is disagreement about the precise contours of privacy legislation, surveys suggest this discomfort about the use of personal data transcends party lines, helping to overcome one barrier to collective action on the part of community members and their representatives. That said, the insecurity of undocumented persons in our communities is a matter of grave moral concern. We might hope that the experience of COVID would teach us that failing to protect their interests will make undocumented persons much less willing to reveal the information we need to keep all of us safe. And so we might hope that this would be an opportunity for citizens to bargain on their behalf. Unfortunately, I am much less sanguine about that possibility. Let me put the issue more generally and return to the theory of democracy. There is a temptation to regard the aggregation of local knowledge as an unalloyed good, a necessary condition for the achievement of good outcomes, an achievement at which democracies, at least in principle, can excel. COVID data is different from the type of knowledge that the Crown sought to secure, but it is nonetheless fine-grained information held by citizens that a state wants to maintain order. The type of knowledge that participatory deliberative institutions such as citizens' juries today seek to gather is quite useful information to a state that wants to learn about citizens' personal experiences and how these experiences might shape their preferences. Now, the inclusion of ordinary members of communities, particularly vulnerable members in these communities, in these bodies as bearers of local knowledge does reflect respect for them as epistemic agents, as well as political agents. But when respect for persons as epistemic agents improves state access to the information they possess at a granular level, there may also be costs to their privacy and to their security as persons. A state may use the intimate knowledge of its citizens' lived experiences gained through deliberative bodies to improve its techniques of nomination, absent stringent norms governing the use of such information. And so the basic precondition of knowledge provision must be accountability for those to whom we convey it and who then deploy it for some ends. Constitutionalism, here in the form of tight legal constraints on state use of personal information and on individual rights of privacy, is surely essential for these purposes. But courts alone cannot solve the problem for us. We require legislation and potentially direct public action. Finally, accountability is double-edged. Government officials that fear that they will be held accountable for bad outcomes may decline to collect information that they believe will cast a negative light on their performance. My governor, Andrew Cuomo, is alleged to have done just this in undercounting nursing home deaths. So meaningful accountability for the collection of information requires not merely the threat of constitutional litigation, but the presence of a robust opposition party and a free press capable of shedding light on malfeasance. And meaningful accountability also requires collective action on the part of citizens to resist when the state's collection and response to local knowledge puts themselves or other community members at risk. This is the challenge and the promise of what I pray will soon be the post-COVID era. Thank you.
Thank you very much, Melissa. That was wonderful. At RGCS lectures, the first question is reserved to a member of the RGCS Student Fellowship. And I'll remind people to please use the raise hands function so that I can see and keep track. And other people are free to raise their hands and get in the queue, but I'll wait a moment until I see the first question from a student fellow. I'm patient about this. Nessie.
Hi, thank you for your talk. I guess I have a two-part question, and that would be, I wasn't sure how the final points about the freedom of the press and accountability for data ownership connects with the medieval England story, and especially considering the local knowledge in the modern case is already commodified and privatized and owned by companies. It's not owned by us, so we're not agents in control of that data anyway, as were these peasants that you're talking about. So I'm wondering how that connection plays out in your theory.
Yes, so those are two parts wrapped together. Yes, a perfectly fair question, because you're right to say that we don't have an unmediated way of sharing this information. So this is not the way in which this information is collected by us and transmitted to the state is mediated in the way that you suggest. I think nonetheless, there is an analogy to be drawn between under what circumstances are we willing going forward to participate in something like a state. It is true that a state app like this Excelsior app would still require some sort of private company, but we may decide that we were going to decline to use it until the state actually specifies the circumstances under which we would do it. So there's a mechanism in place by which we can resist. And what I'm trying to argue, in the parallel to the medieval case, is this: is that even medieval peasants were able to recognize that the state's use of that the state had an interest in gathering information, but that they had means of resisting these entreaties when they thought that it was not going to be in their interest to provide it. It may very well be, and I don't want to say that it's not in our interest to provide this data to our states. Again, it has been, crucially valuable in the fight against COVID. Here I am fully vaccinated in my office. To me, this feels miraculous. It is a function of the fact that I was able to provide this information to the state, and I don't want to minimize that. But I do think prospectively, we need to think about, having been willing to give up all of this private, medical, personal information, what we want to expect our states to do with it, and our private corporations prospectively.
Kevin.
Thank you for a wonderful talk. When in hearing previous sort of versions of this and hearing, oh, I'm researching the medieval juries, and being able to forge a connection to such contemporary issues is Profoundly impressive. So I just have a couple of questions. One is sort of following a sort of slightly more political version of Nessie's question, and that's because it seems to me that and so maybe this is just sharpening the question a bit. It actually seems like the technology that we have today that provides this information can be utilized in ways that ultimately deprive the users, us, the people, from the kind of bargaining power we might otherwise have. So this is less to do with it's been privatized rather than the mediated nature of these seems to make a difference in the key variable of bargaining power, right? You can, if it has a GPS chip in it, they have that data whether you consent to it or not. So I think maybe there is where there might be an interesting research on strategies of kind of like unplugging people. You know, the old kind of like cancel Facebook thing is one thing, but then, you know, active strategies of crippling tech, of thinking about and talking about the costs of opting out. What would it mean to like not carry any device that has a GPS tag in it? And so partly that then becomes partly a matter of like social norms and what we expect from each other. If we expect to be able to reach each other immediately, then we're all in this boat of having a GPS thing. The one other thing is that I wonder to what extent your point about citizen juries and how they could become tools of domination. Isn't that kind of already happening with another thing that we don't call juries, but actually are very much what they are, institutions for revealing local knowledge? We just call them focus groups. Because focus groups, right, are explicitly used to test messages by political technicians who are trying to manipulate the public with them. I wonder.
Yes, to both. It's hard for me to challenge either of those points. I think they're both right. I think it is true that to actually effectively engage in collective action would involve depriving ourselves. There are very great goods of this technology. You know, I personally like being able to track my child's movements throughout Lower Manhattan. It is one of my favorite things to do. It's, you know, but I recognize that the fact that I can track my child means that lots of other people can track my child too, which is deeply troubling. And so, yes, thinking about how much leverage we're willing to give up for the sake of these conveniences is a very serious question, and I appreciate it. And the second is, yes, focus groups. There's just a proliferation of these types of institutions that are designed to give people unmediated access to citizens, their experiences, their preferences, and it's very much in corporate interests. It's in representatives' interests to gather this information. So we want, let me say, our representatives to know what our preferences and interests are. It is a very good thing, but in giving that up, we also want to be able to sanction them. And in too many different institutions, I think, we have essentially forfeited that ability to sanction. And I think we should be concerned about that.
Shall.
I want to start by saying I loved your talk. And I want to go back to the medieval period for a moment for my question. I'm really interested in your accountability argument. The part of the motivation of people getting involved in juries, especially from the lower classes, was because they could hold officials accountable, or people within their local communities who are of higher ranks. And I'm wondering if you think the motivation in doing so was an actual ability to affect political change, or merely the sentiment that they could, in theory, affect political change. And I think we could even make a really interesting connection to the modern day and how we consider participation in democracies more broadly. Is it the sentiment that you can actually affect political action, or the observable results?
Yeah, that's really interesting. I think both. I do think that this sort of small bore questions, small bore issues that we see petitioning seeking to get remedies for, was in certain cases effective. I think petitioning about royal would sometimes get abusive officials removed or sanctioned in a variety of ways. So I think there were, was there sweeping political change? Perhaps not, but the issues that people found to be oppressive in their daily life often was able to be remedied through these mechanisms. So that, but I also have been, it's also important for me to say that, yes, the fact that people had the standing to be able to participate in these institutions mattered, I think, very greatly to them as well. That, for people whose families, their reputation, their ability to swear oaths, there are a variety of different types of opportunities that were precluded to the unfree. And to be able to shed that sort of, those stigma and those associations with it, this to me, I think, would have been a very important dimension of what people hope to gain politically.
Rob Goodman, Rgcs postdoc alum.
Thank you. So one thing that really interested me in the talk, among many things, was the quotation from the 40 Shilling Act, the preamble there, when it was describing part of the reason for having a property qualification that had to do with the stake or the lack of stake of poor peasants when it came to making decisions. I think the idea was that because you have such a little property stake in the society, the costs for you of giving bad information or inaccurate information or getting it wrong are lower than the costs of someone who has a greater stake and greater property. And it's interesting to me because I know that that's such a prevalent argument in the annals of counter-democratic thought. You can see it coming up again and again, and I was surprised to see this in an early instance of this. So I guess what I wondered is if in your research you found any discussion of the kind of any kind of resistance to this argument. If all the resistance was sort of the James Scott quiet shirking variety, or if there's more vocal resistance to the idea of the stake in property terms as a reason for a political qualification. So I could think of different ways of resisting that argument. One could be that, of course, even though I'm below the 40 shilling threshold, of course I have a stake. It matters to me whether the king's officials are corrupt or not. It matters to me if taxes are oppressive and so on and so forth. And that's one way of arguing against that point. And I guess another could just be the idea that this whole idea of a sort of property metaphor as a qualification for political activity is just misplaced, that there are other justifications for expanding the franchise when it comes to you choosing who would represent you as a knight of your shire. So I wonder about the history of that kind of argument, the argument of a property stake when it comes to allocating who gets a political voice. And if you saw in your research resistance to that sort of way of conceptualizing who doesn't get to participate.
I have not yet seen that, and that so there are a couple of possibilities. One is that I have not yet going through. That I have not encountered it, and the other possibility is that it doesn't exist, and it might not exist because there's no record of this, because the records of the types of arguments that were going to be made about political rights during that period very well might have not been. We may not have that in a corpus, so it's difficult to know how to answer that question. I associate with a later period, but perhaps I am mistaken to do so. It's hard for me to imagine in the period that people would say, well, it does so much of people's value and worth was associated with land and
Can you hear me? Hi, thank you so much. Excellent talk, really, really interesting. I love getting the historical perspective. So my question is more towards the present, and it's about the question of the public-private divide and whether kind of the current crisis, the crisis of the pandemic, is calling for a renegotiation of the public-private divide, and one that there are some good reasons to think should be renegotiated in the face of a major health crisis that's affected so many people, but one that I think, as you have pointed out, raises a lot of questions about what this is going to mean, especially in the context of a conference on constitutionalism in a free society. There is the idea that in a free society, one of the major limits on government is that it's not going to be kind of peering into people's bedrooms or into their health habits or tracking people wherever they go. And most people would think that kind of that is a differentiation between a more despotic form of government or a more totalitarian form of government, and one that purports to be a constitutional form. And do you think, when you talk about what's going to be needed, I mean, is there a need for a public debate on the public-private divide and how it gets sort of constituted? Because a lot of what's been happening with the slippage of private information has gone on, I'll call it under the radar, right? So partly through these kind of agreements between, at least with reference to kind of data privacy, agreements between private companies and government that go on without people really being very aware of it. So I just am interested in your thoughts about what this means for public-private if we're moving in this direction.
Yeah, I definitely think that this is, you're absolutely right. I think that this is, there's scope for this. I fear that so much of public debate about these sorts of questions ends up being hyper-partisan. And so one of the promising dimensions of it is that so many people are, I was looking at a Pew survey about the distribution of people who are by governments, but also by tech companies. And in fact, as I said, it transcends party lines. So the hope is that this would be an opportunity for this sort of public debate and ultimately legislation that would be able to contest these would be able to think more clearly about the regulation of this information and the regulation of the use of this information. I worry, though, that when the activity of crafting of legislation is going to happen, the contours of it are going to end up dissolving into the same sorts of partisan challenges that we've had. I want to be more optimistic than I am. I think we desperately need to have the conversation. Will it yield meaningful results? Your guess is at least as good as mine.
Victor.
Hi, so I always love a good medieval story. And I was wondering, however, my question is actually more about the contemporary example, and the parallel that leaped to mind was more the collapse of the polling industry over the last couple of elections, which seems to have been due by information to companies that are perceived to be part of that great mysterious elite. And so at first glance, I thought this is a perfect parallel in terms of the necessity to provide local knowledge in order to effectively govern, because so much of our governance is actually not driven by the election itself, but by the crafting of agendas on the basis of polling. But the difference is that the examples that you bring up from the Middle Ages are of the kind of claim or the kind of demand that local groups would present in order to provide that information are pretty concrete and actually quite sensible. I mean, they if anything, they're sometimes too modest, maybe responding to a kind of moral economy of the peasant. Just fix that dam, fix that road, fix that bridge. That's the least that we expect of the local lord. where it's not clear what kind of demand the silent Trump vote, for example, would present, because the vote is more, it's either a complete grievance claim that just simply cannot be met, or it's a more ambiguous kind of trust and respect claim that it's unclear how it could be met. So I was wondering what you thought of, I mean, is this a proper parallel in the sense of the local knowledge, and is it a proper non-parallel, I suppose, in terms of the remedy that the aggrieved could present to provide information?
Yes. So in addition to the collapse of the polling industry, which is a problem, I'm deeply worried about the collapse of the local newspaper and local media outlets in general, both in terms of being able to make claims and to be able to have claims heard, and the specificity. So I share your enthusiasm for the specificity of the claims made by peasants. And one of the wonderful things that local newspapers were able to accomplish was the specificity of the needs and the grievances of local communities, and possibly the ability of local leaders to be able to both to try to remedy them where they can, and to yoke them to broader national concerns. And with the lack of with the nationalization of the media market, we've lost that crucial link. And so I would say that this is a worrying development, one that is depriving us of a type of local knowledge that we desperately need.
Helena.
Hi, thanks for your talk. I guess my point is just quite an empirical one, but it's supposed to be a bit of a pushback against the kind of pessimism about technology I heard in some of the questions or comments. And I just want to draw attention, I guess, to the fact that Taiwan also has dealt really well with the pandemic, and they have made use of a lot of technology also in the process, I believe. So there's just like this one anecdote, I guess, where they wanted to implement like a countrywide, or they were out of stock of masks, so they didn't have enough masks to implement the coverage of mask wearing that they wanted, I guess. And then there was like, also I think this is probably specific to Taiwan as well in some form or another, but among the tech community, people kind of noticed this and then came up with like crowdsourcing platforms to source the data of where masks were available and where they weren't in the stores. And then this actually got taken up by the government, because it turned out that providing this service, this crowdsourcing platform on their own proved kind of costly because of the tech giants involved, or like the platform on which they hosted it. But then the government was kind of able to incorporate this data system into their databases basically and make it available for everyone that way. So like, yeah, I think that's just like kind of to draw attention to like the spirit there. And I don't know, maybe that's a bit of reasons for optimism or something.
Well, for sure. There are large-scale logistical challenges that tech enables us to respond to effectively. I would never deny that. I do want to think about what's going to happen to the use of these tools post-pandemic, and whether tools that are designed for really, beneficial uses, as you suggest, can be put to more nefarious uses. And so my challenge is basically just to suggest that we think more carefully about what types of institutional norms we believe a free society or a constitution in a free society should seek to implement so as to minimize these risks and to be able to harness the benefits, which again, I think are significant.
Jeffrey Lenowitz.
Hello, thanks for another great presentation. I'm always impressed by and envious of your ability to know the history so well as the theory. So I just have two kind of path-baked questions. The first is just from your story, about which I know nearly anything. It seems that the upwardly mobile peasants would have just been better jurors, and that they would have been more willing to tattle on their betters than those betters would have been able to tattle on themselves. Was this just a happy coincidence, or is this another source, another reason for moving lower peasants to juries, and that they would have been better at producing the kind of information that was needed as a result of the financial deficiencies wrought by the plague? So it seems like that could be either it's a happy coincidence or is it another cause for what you're seeing, rather than just simply a shortfall of jurors. It's also that these people would have been better at or more willing to give up that information. So that's just one kind of question on the history. And the second is just, I mean, this also seems to be a story about how as states have gotten more expansive and more powerful, our opportunities for bargaining have been reduced. And that I can't think of a way in which there would be a version today of an upwardly mobile peasant who would withhold local knowledge to get something from the state. What we know will happen is the state will just say, of the many thousand things I do, I won't let you do them anymore. Which is, what happening with people can complain all they want about COVID passports, but if they need to give their tracking data to go to a restaurant, they're going to do it. And so the part of the story is just how, this was a wonderful opportunity for these peasants, but now it's much more easy for the state to make us give up information. So I just wanted to invite you to kind of sketch an example of how we can be upwardly mobile peasants and extract a bargain from the state.
Yes. Okay, so on the first, was it merely a coincidence? No, okay, so it is clear that even pre-plague, there were cases, not just because these sheriffs or bailiffs found themselves with a shortage of qualified jurors, but they thought, well, in this particular community, the people who know this really well are likely to be these villains who are in proximity. Same thing with women. The people who a woman is in the best possible position to know whether this person is a virgin or is pregnant or whatever. So yes, sometimes to a certain extent they're going where the knowledge is. But the issue was, I think, at this particular moment, was that they also were aware of the fact that the more they were relying on these jurors, the more likely they were going to be to demand other claims. And they anticipated the decline of serfdom. And so some of them wanted to resist that. Some would have thought, well, look, these people are actually, they're epistemically unqualified. They're ignorant. And so they don't actually know the sort of information that we want. They may have a view on it, but who really cares? So partially coincidental, partially not. On the second question, so how can we be upwardly mobile peasants? How could we possibly achieve resistance to these devices? It is true. I would have thought, for instance, that states would have had relatively little bargaining power with the federal government vis-a-vis the revelation of the data in exchange for the vaccines. I think the fact that states were able to stand up to the federal government and be able to shield their citizens from having to provide that information is a positive sign. So would you or I be able to be an upwardly mobile peasant? Perhaps not, but perhaps local levels of government, state levels of government might be able to more effectively advocate on our behalf. Of course, here I am in New York State. Am I going to be able to fight with Cuomo? No. Bill de Blasio might be able to. He may also lose for a variety of reasons, but he'll be bargaining about something like that.
Ryan Pepe.
Thanks, Jacob. And thanks, Melissa, so much for that talk. I really appreciated it. So as long as you don't tell me I need to hang my hopes on Bill de Blasio. Yeah. Actually, I have a question that's really similar, I think, to Jeffrey's second question. So maybe this is in a way a follow-up. I think I'll maybe put the point slightly differently, but I think it's a version of the same kind of question. So basically, I want to press a little bit on the idea that the informational needs as such actually give us any leverage. And I'm not sure that it's true. So if I understood right, not knowing anything about it really, in the medieval case, because the state can't really access the information at all without people's consent, people end up having a certain amount of leverage vis-a-vis the state. It's not clear to me that the same mechanism exists in the contemporary case, because the state, given the kind of information they want and given their technological capacities, can just claim the information. I don't even think in many cases they need to do what Jeffrey is saying, that is sort of pay us off for the information. They can just take it. So think about China and Russia, they have informational needs that are very similar to our state's informational needs. And they're just going to claim this information in the COVID case, just like they're claiming the information in all these other domains. And it's not really allowing their citizens to be upwardly mobile. I think if we have more leverage as citizens of New York than the citizens of China do, it's not because there's some difference in informational needs in the two cases. It's because we have a pre-existing institutional way to threaten our rulers that doesn't exist in these other cases. But this allows us to leverage the leaders even when they don't need information from us. But that suggests that the information is inert. It's aside from the point in the story. We have leverage, whether the state needs information or not. Chinese citizens don't have leverage very much, whether the Chinese state needs information or not. So it's not clear to me where the informational need is coming in here, although I understand it in the medieval case.
Yes, so I absolutely agree that there is no difference in the informational needs across states, and that it is a mistake to think that it is only tyrannical regimes or only democratic regimes that is able to harness this information. I share that, and I also share the view that yes, it's about the institutional incentives that we have in place to get our rulers to respond to us. Your claim, if I have it right, is that means that the informational, since we all need information, means that there's nothing special about information. I do think that there is something special about information. It's true that in terms of the type of GPS data, is there anything special about GPS data that enables us to have some sort of special constraint on use? No, but I think that there are other cases in which, if we imagine that our representatives are responsive to the interests and preferences of citizens, and that they're more likely to get this info, that they have other means of getting this information, or we have other means of conveying this information to them, and that other authoritarian regimes might, because they can't provide security to their citizens, may not be able to get the same amount of reliable information. I do think that there is a way in which there's an opportunity for bargaining on the part of citizens that there might not be in another regime. So that was sort of a roundabout way of making the point, and let me see if I can do it a little bit more precisely. So all states need information about COVID. Not all states, perhaps I'm putting the point too strongly. States also need information about the preferences and interests of citizens. What they're going to do with that information is going to vary. They might end up using resources to buy off particular rulers or particular members of communities. or they might be able to tailor policies that are responsive to citizens. So my hope is that if citizens are going to be giving this type of information to the state, that they're going to be able to generate more responsive policies in response through an accountability mechanism like an election than they would be in another, under another types of regime, that they will be able to do so more systematically than they could elsewhere. That is a conjectural point, and it will not always be the case. And I wouldn't say that elections are perfect accountability mechanisms. That would be a mistake. But I don't think that it means that information itself doesn't matter, or that there isn't anything special about information. There just may be something special about political information as opposed to health data.
We are right at time, but Melissa Williams has been waiting on the queue for a long time, so I'm going to call on Melissa, and then I'm afraid I'm not going to call on Mila, who got onto the queue just a couple of minutes ago.
Oh, thanks so much, Jacob. And thanks a million, Melissa, for a fantastic lecture and talk. I wish I could have attended the entire conference the whole time. It's been what I have been able to do has been great, but this is really exciting work that you're doing. I think my question really does kind of pick up from the questions that Jeffrey and Ryan were just posing. And I guess also just to I'm wondering whether there might be a disanalogy between the two periods, and maybe it might be worth disaggregating two elements of the overall puzzle, where, you know, in the medieval case, which is fascinating, you have in the first moment the state increasing democratic empowerments in exchange for the information that it needs to govern. And then in a second moment, you have citizens who have been empowered within this rubric, then withholding information in order to heighten their power within the system. Now, and so, I mean, I guess there's partly a question about sequencing. That is, can the withholding of information be empowering for citizens if they have not already been empowered? And we can imagine some circumstances in which that might be the case, such as, like, I was thinking of another thing from James Scott, the weapons of the weak. You know, is this a weapon of the weak that's really being deployed here? On the first piece, I'm sorry, I'll try to be quick. There's some other examples we might bring into the picture for comparative purposes. So, for example, the work that Bao Gonghe and Mark Warren did on deliberative authoritarianism in China, where the state was, for a while anyway, increasing local democratic empowerments for governance purposes. We could also look to colonial contexts. I'm thinking of my former student, J.B. Matthews' work on representation in colonial India, which was initially basically an information gathering strategy. So there you get, you know, democratic empowerments of one form for the sake of the state's interests and knowledge. But I'm wondering here whether, you know, that piece, and I think this is just echoing what Ryan and Jeffrey were saying, that piece is absent in the current context. That is, that the state's interest in knowledge doesn't require it to increase democratic empowerments in the moment that we're in. Sorry, that was a bit long-winded, but I hope some of it might be helpful.
No, it is helpful, and I see the force of it, and I see how it links up to the issues that Jeffrey and Ryan were raising. That yes, the COVID case is an imperfect one because it's not really about giving up political standing as such, or it's not really a bargain about political standing. It's going to end up being a bargain in a way about constitutional rights. Are we willing to sacrifice? Under what circumstances are we going to be willing to give up this particular domain of information that we didn't previously give up in exchange for some outcome? And it may be the case that the state can just take this information from us. But I do not being an engineer or somebody who really knows very deeply, is effectively a Luddite, I could not tell you how much leverage we have in terms of being able to secure the conditions of our information, whether or not there are ways in which one can disabling GPSs, disabling various forms of sharing sharing settings, whether that is a way in which we can refrain from giving up information to the state. I think if we could, then we might see this dynamic play out, and the state says, well, look, this is what you're going to be getting in exchange for this under these circumstances. And if they overstep it, can we credibly commit to withholding this information? It's possible that we just can't, that the bargaining game just doesn't play out this way. But the hope is that perhaps it might enable us to use it as a lever to improve standing for people who lack it otherwise, and say, look, at a minimum, if you're going to be trying to extract the information, if you're deeply concerned about the movement and the tracking and tracing of undocumented persons, at a minimum, it means you have to be prepared to give them access to driver's licenses, or these things that they need to be able to secure themselves and the welfare of their families. Possible, but there too, there is a trade-off. So unfortunately, I do not have clear answers to our contemporary dilemma. I wish I did.
To close out this keynote lecture, we wish to acknowledge that the Conference on the Constitutionalism and the Free Society is supported by a grant from the John Templeton Foundation and by the Jan P. Lynn Center, and that the Rgcs lecture series is supported by additional grants from the John Dobson Foundation and the Institute for Liberal Studies, to all of whom we are very grateful. The conference will resume tomorrow at 9 a.m. All of you who've registered, if you came just to this lecture, you are registered for the whole event, and the same Zoom among us for our continuing conversations tomorrow at 9 a.m. And now everyone, please join me in extending a very warm thank you for this outstanding lecture to Professor Melissa Schwartzberg.
Thank you so much. It's really been a pleasure.